Trump beats Chutkan and Jack Smith. They are not having a good day. Judge Chutkan issued an order saying that Trump is right. Trump said, you can't have any January 6th trial in March, you crazy. I'm appealing your rulings on presidential immunity and other things. And by appealing it, it pauses everything, literally everything. Okay, no discovery, no SEPA this, no this, that, the other. None. You're done because Trump is freed from the burdens of litigation while it is on appeal. Now, Jack Smith, as we've been covering here, filed a bunch of motions, and now he's freaked out about this. He's like, we have to have trial in March, the day before Super Tuesday. He's so freaked out, he took this up to the Court of Appeals, and he took it to the Supreme Court simultaneously while he was replying to Judge Chutkan that we covered previously, saying, Judge, don't listen to Trump. You can still keep the train on the tracks here. Keep the trial in March. Well, Judge Chutkan came out and said, sorry, Jack, Trump's right. Oh, and that stings for them. Oh, man, they're not happy about that. And so we're going to see here, Chutkan agrees. Now, it's a 3-page order. We'll get there, but it's going to be much more satisfying if we see what Trump's final word was, because he dropped this today as well. He said, all right, Judge, this is the last word. And we've seen Trump's responses on this previously because Trump has been very aggressive, I would say. Trump has been saying, Judge, you don't have any choice at all. By virtue of our appeal and the rules, this is taken out of your hands. And Jack Smith got very nervous about that. So we see this is a 9-pager out of Judge Chutkan's courtroom, District of Columbia, United States of America, Jack Smith and the deranged thugs of the DOJ versus Donald Trump, saying this is President Trump's reply in support of the motion to stay the proceedings. Now, we're going to read Chutkan's order as soon as we're done, but here is their final word. They say, all right, Judge, as she's sitting there editing, she's like, are you sure we can't deny this? Are you sure there's nothing else we can do? Her court clerks are like, sorry, Judge, it's like the Supreme Court. Trump and his team says, all right, Judge, listen, hours before initiating proceedings before the Supreme Court, Jack Smith, as he did, in order to try to complicate Trump's as of right appeal in the DC circuit. Okay, Jack Smith tried to leapfrog Trump and to go right to SCOTUS because he's out of time. The prosecution filed an opposition brief that ignores Judge Chutkan, the Supreme Court's binding precedent, and it urges you to permit continued pretrial proceedings on a parallel track. And we read that in yesterday's show with Thomas Wyndham, subsigned by Molly, saying the prosecution's brief was ambiguous about what they had in mind, but today they filed a SEPA Section 6 hearing, which the court currently lacks jurisdiction to conduct. So they're saying we don't really know what the government was asking for, but they're just like keeping the train on the track. Like you said, the train stops and they're driving it to the next stop. They said, hey, let's schedule the SEPA hearing. And they're going, what? No. Judge Chutkan, you don't have jurisdiction over this, like at all. You can't even hear the case even if you wanted to. So notwithstanding the prosecution's overlapping and still pending motions, says the court currently lacks jurisdiction to resolve those too. Now, the only coherent principle that emerges from Jack Smith's filing, only coherent, is based on strategic gamesmanship rather than on the law. They're acting on behalf of the Biden administration, saying the prosecution will do everything that it can to rush an unconstitutional and fundamentally unfair trial to try to prevent President Trump from winning the 2024 election, which he is currently leading. Now, the prosecution's frivolous and unsupported opposition demonstrates their improper motivation and their desperation. That's true. The stay sought by President Trump is mandatory. When I appealed it, you had no choice, and the prosecution knows that. The court, they say, it says here, they quote it, must. You see that word, Judge Chutkan? See that? Oh, look at that one right there. Must stay its pretrial proceedings. And where did that case come from? Oh, look at that right there. The U.S. Supreme Court. That's what that symbol means. So that's pretty serious authority, isn't it? Must, not may, must. The scope of mandatory stay is also clear. What does it cover? The entire case is essentially involved in the appeal of a motion that is challenging immunity and double jeopardy. That comes from Griggs. Where does that case come from? Oh yeah, the Supreme Court, another one. So the many district courts faced with similar appeals and motions to stay after having denied immunity determined that a stay of all proceedings right there is also valuable. Now they say, indeed, a district court issued exactly the type of stay that Trump requests here when Clinton was appealing a similar issue. The Jones versus Clinton case. That's the Clinton sock drawers. And so they say, look, it's happened previously. The Supreme Court makes it pretty clear. Sorry that you're trying to squeeze this one through here, but we are not buying it. This court must do the same and find that everything is stayed. Now, until the appeal is resolved, Trump's defense says, any further district court proceeding would be a nullity. You'd be wasting your time, it'd be void. All existing deadlines are no longer in force. Judge Chutkan, that's our order to you. And this court lacks authority to issue decisions on pending applications. You are done. To the extent that circumstances arise that Jack Smith Smith and the deranged thugs there believe warrant lifting the stay, they can seek the relief at that time. Now, unless that unlikely event happens, however, the proceedings must be, and they are, stayed. Thanks, Judge. Now, here's the basis for this filing before we get to the judge's motion or order. It says here, the prosecution even concedes, as it must, because there's no case law that refutes it. They agree and admit that Griggs, the case from the Supreme Court, it applies automatically when you file a notice of appeal. You literally lose jurisdiction. The district court is divested of its authority over the case. It's gone. The prosecution, Jack Smith, they also admit that while the appeal is pending, President Trump, they acknowledge, they say, will not be subject to the burdens of litigation. Now, isn't that nice that these prosecutors will say that in one filing and then literally the next day turn around and submit a request for a SEPA Section 6 hearing? Yeah, we agree that he doesn't need to be subjected to the burdens of litigation except for SEPA, which we're going to file tomorrow, and except for this, which we're going to dump over tomorrow. And we're going to dump a pickup truck of unrelated, unnecessary discover, another 2 million pages down your gullet on your front porch. You know, they're just talking out of both sides of their mouth, obviously. So they say here, it follows that even if Jack Smith is going to make these concessions as they've done, even though they're not acting like it, the binding precedent upon which they are based, they say that this case must be stayed pending appeal. That means everything. Trial and pretrial proceedings as well. Comes from the Supreme Court. Now, here is what they say is specifically stayed and stopped. Bunch of stuff. They say, all right, Judge Chutkan, and she's reading this just fuming, okay? You know those smokes that come out of your ears, like Elmer Fudd when he was chasing Wile E. Coyote? That guy. Bursting at the courthouse. Says, hey, Judge, hey, just wake up over there. Due to the automatic divestiture of this court's jurisdiction, you're done. All existing deadlines are not in effect, and pending motions must be held in abeyance. Feels like they're kind of ordering the judge around, you know, it's kind of nice. Now, this includes all existing deadlines and pretrial submissions should they become necessary following the appeal, such as, and without limitation, Trump is not doing any of the following, just so you know. Further briefing on President Trump's pending discovery motions. We're done. We're not working on it. Motions for Rule 17 subpoenas. We're not even thinking about them. No subpoenas even being thought about. The reason why they're listing this is so that if something comes back on trial, like the Supreme Court comes back and says, you know, in second thought, everything looks good, trial can move on. Chutkan says, okay, well, I guess you don't have immunity, so trial's on for the 4th. Then Trump can say everything from this moment in time, okay, everything, like this is the legal reason why they're articulating this so clearly, is they're saying everything from this date, from 12/12, just mark the calendar, however many days. So we're going to pause this trial, step out, go somewhere else, go vacation at the Court of Appeals, and then we're going to come back. We better find this exactly how we left it. Nothing better change. And you're going to see, right? So however many days that is, so let's say it's 2 weeks or 2 months or 4 weeks or whatever. We come back, the government's going to say, hey, we're ready to go. Like we're ready on all of these issues, okay? They're going to say, we're ready on trial. And Trump's going to say, no, sorry, we stopped working on this whole list. Like this is our notice to you. We're not even looking at this. Don't even ask about it because we're on appeal. And so every date from between, you know, the 12th up until, you know, whenever this is, let's say January, is now, we got to go back to the drawing board, Judge. And now let's reconsider Motion 17 subpoenas, Rule 17 subpoenas. Now let's talk about discovery. Now let's talk about advice of counsel defense. Remember that issue that popped up? SEPA submissions and hearings, all that is delayed. Classified evidence described in his notices and so on. Any anticipated objections that you're expecting from our side, they're done. Any expert witness disclosures. We know Jack Smith wants to use Trump's alleged cell phone, apparently that he had in his possession, to say where he was pinpointed within the White House and evidently what websites he visited and so on. But Trump is saying, we're not telling you anything. Any suppression motions, okay, we're going to be filing a bunch of those. We're going to try to get a bunch of evidence dumped. Any motions in limine, preliminary motions, we're not even thinking about those either. Any proposed voir dire, jury instructions. Remember, the jurors have already gotten notices. Hey, we'd like it if you're available here. A bunch of DC jurors are like, the Trump trial? Perfect. It's like going to Disneyland, which is probably their second favorite thing. Now, exhibit lists and objections are also not even thought about. Witness list, Trump's not providing. Any written questionnaires for jury selection. And guess what? Look at that final bullet point. Trial. Oh, man, that's so good. We're also not preparing for trial, Judge. Not even thinking about it. Thanks, though. You guys sure you don't want to do... No, we're not. We're good. Thanks for offering, though. So the court lacks authority, Judge. You have no basis to even address the pending motions. And any decision, if you issue a decision on this, would in effect be an advisory opinion that we could just dump into the garbage regarding the court's views and other aspects of the case that assumes away critical flaws relating to immunity and double jeopardy issues that are now on appeal. Okay, Judge, we think, in other words, you don't have any authority because Trump has immunity, and that this case is not even lawful because it's already been tried in the Senate and Trump has already been acquitted on it. Now you're trying to convict him again. So Court of Appeals tells us differently. We're done listening to you. Thanks. Now, such decisions, if you did decide against us, Judge Chutkan, right, they're really like digging a line hint, and I love it. If you think about issuing such a decision, well, guess what? That's going to result in unprecedented confusion with respect to the procedural requirements that would typically follow from orders that are based on the appropriate exercises of jurisdiction. In other words, you're breaking the law. You're inappropriately exercising jurisdiction over something you don't have. Now, such as time periods for reconsideration motions or mandamus petitions or interlocutory appeals. Now, they need to consider and potentially pursue these options, and the need to do that is one of the burdens of litigation, and you're not allowed to impose any of that on Trump during this appeal. And by the way, don't listen to the government with their Rule 37 garbage. It's nonsense. Nothing in that rule supports their lawless proposal. The rule just simply recognizes the Griggs principle, all right? And the rule authorizes a district court to deny the motion after this, but they say it's inappropriate here. Now, the advisory committee noted that the rule will be used and blah, blah, blah. Now, therefore, this citation is yet another example of the government failing in their obligation to seek justice, right? The sensible course of this is it obviously a mandatory stay. If there's a dispute about this in the future that they believe that somehow this falls outside of the mandatory stay, then they can lift the stay at that time. But there is nothing here at this moment that justifies you keeping jurisdiction over the case and saying, guess what? The government just can't litigate against Trump in absentia, right? Trump is working elsewhere. His team is no longer at the district court. They're at the Court of Appeals. Now, the government wants a parallel track. They just want this thing to just keep moving forward. Trump needs to be there. Hello. It takes two to tango in a trial. So they say, look, ignoring these realities and without any legal authority, Jack Smith and the deranged thugs over there, they propose a bizarre one-sided proceeding where Trump is absent. Now, in their dream world, notwithstanding this court's divestiture of jurisdiction, which you have no authority over this case, the prosecution would continue to file false motions with inaccurate descriptions of evidence in order to harm President Trump's reputation and bolster President Biden's losing campaign. So good. Because the court doesn't have any jurisdiction. But they're like, can we keep sending you love notes, please? Hello? No, you can't. So it's bizarre. And they know this, right? And the court, they say, would make headway by just issuing a bunch of advisory opinions when the court doesn't even have any authority to address it. Saying ridiculous. This is flatly inconsistent with what the court has described in the rules. This politically motivated gamesmanship by Jack Smith and them driving this request is illustrated by the government's assertion that their purported plan to comply with the, quote, pretrial schedule, that it's subject to the length of the appellate process. Here, in other words, Jack Smith and Molly and Thomas, they asked the court to unlawfully reserve jurisdiction over Trump while at the same time reserving for themselves the option of ignoring the court's schedule if the appeal is not litigated in a manner they deem to be sufficiently expedited. So it's great. Saying, hey, basically asking the judge to take the case back from the Court of Appeals, which is very inappropriate. You just want her to keep moving this case forward when it's not hers, it's theirs. That's how it works. It's a handoff. Two people are not working on the same case simultaneously, but that's what they're asking Chutkan to do. And she's probably just trying to figure out how to do it. We're going to get to her opinion next. So they say, look, the unprecedented suggestion here from them, these are our prosecutors who are supposedly swearing an oath to do justice. This is not partisan. This is not political. These are people who are, good-natured people, evidently, they tell us. But they're just saying that they file these motions. It is contradicting specifically the Supreme Court's recent admonition that it makes little sense for the litigation to continue if you're going to pause these things. Now, such a one-sided litigation where the government can just keep going while the defendant is on appeal, which would involve a prosecutor without a defendant, would be akin to a lock without a key, they said. A bat without a ball, a computer without a keyboard. In other words, it's not sensible. Hello. And so, yes, they say, the prosecution's nonsensical approach would add, it would not eliminate the burdens of litigation in a court that lacks jurisdiction. Don't even have the case. And here, any concept that this prosecution is serving the public interest is a joke. They say throughout these proceedings, Judge Chutkan, Jack Smith has regularly referenced the, quote, public interest, which of course is nothing more than a partisan private interest of the Biden administration in holding a show trial that falsely, unfairly, and unconstitutionally targets President Trump as he leads the 2024 race. Saying the special counsel was not elected, was not confirmed by the Senate. The prosecution has no mandate other than marching orders from Biden. The people didn't elect this guy, like the public, like, we elected this guy to go fix this problem. No, Senate doesn't have any say. It's not a representative portion of the public. He was appointed by Biden and Merrick Garland, and he took his orders from them. Now, under these circumstances, by wrongly invoking the interest of the public that the prosecution does not even speak for, they disrespect the interest of hundreds of millions of Americans like us in an unfettered 2024 election, one in which President Trump just happens to be currently the leading candidate. Now, the true public interest is in a legal proceeding based on traditional notions of due process and recognizing that all presidents must fearlessly and impartially deal with the duties of his office protected by the shield of executive immunity, like, we had for the last 234 years. Like that. That was a pretty good pattern until they wrecked it. And that is what the public is interested in, not cracking open our justice system and bringing it to its end, essentially, by weaponizing it. So for these reasons, the public interest is rooted in the proper resolution of the cases, not in rushing to trial. Rushing to trial is antithetical to that interest. They cite a case. They say, haste makes waste. It's an old adage. It survived because it's right so often. Now, any trial that is devoid of due process and the careful consideration of all legal issues would lack legitimacy, as we see. And such a trial would cause further irreparable harm to a country that's already deeply divided and injured by the weaponization of law enforcement and the deterioration of our justice system. Saying that Jack Smith and the government's race and rush to judgment that was first evidenced by the lying prosecutors before January 6th even happened. This was Molly and Thomas, right? In November 2020, they sent a letter claiming without basis, they sent it over to Bill Barr from the DOJ. They said that any fraud allegations about 2020 were false. They sent that in November 2020, like weeks after the election. There's no fraud. Did you even look into it? No, but we know there's not. Okay. Those same people just got gobbled up by Jack Smith, who's supposed to do this fair and independent investigation. No, he cobbled together the DOJ's, anti-Trump dregs and just threw them on a team. So they say, now that must not be confused with support for the prosecution's inaccurate claim about the public's strong interest in a prompt trial. Now, the appellate proceedings relating to the court's December 1 decision, including the matters that special counsel Jack Smith recently dumped up to the Supreme Court, they say they're going to necessarily detract from the amount of time that the court contemplated for the pretrial proceedings. Now, the judge issued a scheduling order, we know, back in August, and said this is going to be perfect, right? We can have the trial in March. Now, insofar as a just outcome is objective, this will necessarily delay the trial. Obviously, trial's not happening, is what they say. Now, indeed, the court has already noted that backloading the pretrial schedule will not serve the interest of justice. And so, Trump's defense continues, wrapping up, they say, in cases of extraordinary public moment like this one, a party may be required to submit to delay, not immoderate in extent, not oppressive, if the public welfare will be promoted. Now, that concern overrides the abbreviated trial schedule. The public interest lies solely in holding proceedings consistent with due process, resolving legal issues correctly and in due course, and protecting the chief executive's ability to do their job. Issuing the requested stay, as required by law, Judge, is the only way to vindicate these interests. And so, Trump's lawyers conclude, before we get to Chutkan's response, where she admits they're right, they say the court should stay all further proceedings in this case pending the outcome of President Trump's appeal. Respectfully submitted, your friends, Todd Blanche and John Lauro. Great motion. Very exciting to see that. And it's even more satisfying because they're right. This is what Judge Chutkan said. In response, Trump beats Chutkan. Chutkan admits it in this order. It's a 3-pager. And she writes, on December 4th, the court issued a memo and an order. Chutkan says, I told you that Trump's immunity and constitutional grounds was no basis for a dismissal. He was making arguments under those claims. Trump appealed that, and then he filed a motion to stay. And Chutkan says, for the reasons set forth below, the court will grant, in part, and deny Trump's motion. So she's going to grant a lot of this. We'll see what she keeps and whether she's allowed to do that. Now, the filing of a notice of appeal, and she's citing the same Griggs case from SCOTUS, is a jurisdictional event. It's not really, it's about what court has the case. It confers jurisdiction on the Court of Appeals, and it divests the district court of its control. She says in Coinbase, the case we're referencing here, which came out in 2023, the Supreme Court applied the Griggs principle to an interlocutory appeal and the denial of a motion to compel arbitration. Holding any further proceedings before the district court must automatically be stayed, right? That is a recent case. The court reasoned that whether the litigation may go forward in the district court is precisely what the Court of Appeals must decide. That's why you got to stop it. So it makes no sense for trial to go forward while the Court of Appeals is cogitating on whether there should even be a trial. And the court court analogized that it's holding is similar in the context of appeals, things like involving immunity and double jeopardy, which happen to be the two issues at stake here. And so it just gets, better and better. Every time we see this, it's a beautiful thing, because what we're noticing is that immunity and double jeopardy were the very claims, the very arguments that they were making. They filed those motions first, and then they layered on the appeal. So they appealed on the basis, right? Very strategic. So as the DC Circuit recently made clear, a former president's absolute immunity would constitute an entitlement not to stand trial or burdens of other litigation. And so, thus, because Trump has appealed this court's denial of that immunity, whether the litigation may go forward in the district court is precisely what they may decide. So, consequently, Judge Chutkan agrees. She says with both parties, interpreting Jack Smith to really be on Trump's side, saying that Trump's appeal automatically stays any further proceedings that would move this case towards trial. There it is. Automatically stay any further proceedings that would move this case towards trial or impose any additional burdens of litigation. So everything that Trump listed there, pretty nice. Accordingly, writes the judge, and for clarity, just to be clear, the court hereby stays the deadlines that I already issued in our previous pretrial order, and that is good news for Trump. Now, the court emphasizes two limits on this stay. Now, first, as Trump says, the stayed deadlines and proceedings are, quote, held in abeyance, their language. Now, rather than permanently vacated. So if anything happens, I'm bringing those dates back. Now, if jurisdiction is returned to this court, she's like, I will, consistent with our duty to ensure both a speedy trial and fairness, I will consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial, scheduled for March 4th. So I'm like putting a pin in those, man. And if I have any basis for reinvigorating those dates, reestablishing those, I'm going to do it for fairness and speedy trial, and fairness to the parties and blah, blah, blah. But what Trump would do is Trump's going to come back and say, look, any time from December 12th, 13th, when this order is issued, up until whenever this comes back down, so let's say it's January, or let's say it's 2 weeks or 1 week or 2 weeks, they're going to say, oh, judge, come on, we got to move the trial out 2 weeks or 3 weeks or a month, right? The longer that they can delay any action or any jurisdiction of Chutkan, the better, because they're going to just claim more time. We weren't doing subpoenas. We weren't reviewing discovery. We had zero burdens of litigation. So we need the time that we lost. Like, you gave us a certain amount of time. We lost that time. We get it back. You got to move the trial. And now she's going to say, well, where's she going to move it to? Really hard to push it back. She's going to put it in, 6 months back, 3 months back. Now we're interfering with the Florida case. And now we've got other cases like the RICO case coming up in August. And now we've got the election right then. So is she going to schedule it right in the middle of an election? Maybe. It's Chutkan. Wouldn't put it past her. So we'll see. But the March 4th date is looking very iffy, and she is not happy about this. As we said, it's going to have to be taken away from her, and the Trump defense took it away from her, and they literally relied on a 2023 case called Coinbase. Great work. Now, second, the court does not understand the required stay of further proceedings to divest it of its jurisdiction to enforce the measures that it's already imposed to safeguard the integrity of the proceedings. You see that? So she's going to keep jurisdiction over the gag. So I can't really do anything else, but a gag is not a burden of litigation. It's management of the proceedings. And so this is just an imposed safeguard to the integrity of the proceedings. And I can also manage the defendant's conditions of release. I can also talk about protective orders, about discovery. I can also have restrictions on extrajudicial statements and protective jury procedures. I can do all of those things. Now, unlike, for example, requiring additional discovery or briefing, if I have orders and limitations on Trump over those, maintaining those measures does not advance the case towards trial, right? And part of this is, the process is the penalty. You're in shackles, even if you're not in shackles, when you're charged with a crime. When the government investigates you, you're burdened, right? There is a lot of pressure on you, cost of litigation, all the things. But she says, but this is not actually litigation. Now I'm just going to, micromanage your life and what you can say. It's stuff that he already carries these burdens. We've already established that. And so if a criminal defendant could bypass those by just asserting immunity and then appealing its denial, then during the appeal's pendency, the defendant could irreparably harm any future proceedings and their participants. So just go out there, as other people have said, just start, taking out witnesses, throwing them off rooftops, and then just claim immunity, I guess. All right. Now she says, that said, now there is little precedent guiding the application of Griggs to the protective measures. The Ninth Circuit has said they've transferred a motion to enforce a protective order back to the district court, even though the district court had jurisdiction over the merits decision below, right? She's saying, so this is a kind of a questionable thing I'm doing, and just letting you know. But the parties have not identified, and the court is not aware of any guiding precedent in this circuit on this issue. you. So I'm going to keep these things. And there's even less instructive cases in the context of an interlocutory immunity appeal. And so here, additionally, Trump does not appear to argue that the protective measures like the gag themselves are stayed. But if he asks the court reviewing his immunity appeal to take temporary jurisdiction over the enforcement of those measures as well, and the court agrees to do that, then Chutkan says, well, I'm going to have to give those up as well. And that was signed by Tanya S. Chutkan. Oh man, I'm sure she's not happy about that one. That is the ruling and the order from Judge Chutkan. Trump is victorious, and the trial date is looking like it is going to be very iffy in March. And so, great news for Trump, very bad day for Jack Smith and the Judge Chutkan over there. And what's curious about this is Chutkan is holding on to things like the gag and saying that Trump is going to continue to be gagged, even though people like this continue to talk all sorts of bad things about Trump. This is a great clip from Tom S. Elliott on the X platform. It's a supercut from Grabian.com. And I wanted to play this because there's a lot of context here about Trump's gag. Trump can't say certain things about reasonably foreseeable witnesses. We really don't know who that is. Like, there's no public witness list that I've seen about who these people are that he can't comment on. So it's just kind of this amorphous concept. I don't know if Liz Cheney's on there. I don't know if Michael Cohen's on there. I have no idea. But there's a bunch of people here who are saying that Trump is the worst in the world. Talk about stochastic terrorism. Talk about agitating a crowd to take someone out. Trump made a comment about Areola's GF hanging out with Chuck Schumer, and they went bananas. Now listen to these people in this compilation of lunatics explaining how monstrous Trump is.
What would a second Donald Trump term look like?
Well, he cannot be the next president, because if he is...
You can't imagine the things that he's going to do. Mexico, Canada. We can't go to Canada because eventually Canada will become annexed to America.
And shoot visitors to the White House. Yeah, that means he can shoot the First Lady.
We're going to see violence, the likes of which we didn't even see on January 6th.
Make it illegal to run against him, to throw his opponents in jail, to shut down the media.
He will make himself into the Fuhrer, and he will make everybody raise their hand and salute him.
Using martial law against the American people.
Terminate the Constitution.
To rewrite the Constitution.
Create mass internment camps.
Throw everyone into Gitmo.
Might be sent to jail, or their rights might be suppressed, especially minority groups in society.
You might have any number of things happen to you and your family.
Every one of us, our freedom, our liberty, none of us is safe.
It's going to have people around him executing against an enemy's list.
Assassinate generals.
Ordering troops to attack American citizens.
Trump's very well armed and extremist base will try to kill people.
He's going to basically burn the house down.
He will unravel the institutions of our democracy.
Draw similarities between Mussolini and Hitler.
Adolf Hitler and Benito Mussolini.
Makes Donald Trump even more dangerous.
Wants to take away your vote.
Senate and the House are immediately going to be paralyzed.
People will begin in their minds to censor themselves. They might say, well, maybe I shouldn't say this.
This is the end of democracy.
I think that could be the end of our democracy.
But democracy is dead if Trump is reelected.
Cozy up to Putin that democracy will be at risk.
The absolute destruction of the Justice Department as we know it.
The Justice Department could be entirely transformed.
I am really concerned about that.
Every person who was associated with the attempted coup elevated in the administration.
If he's reelected, he will curb transgender rights.
The end of the rule of law.
Arrest political opponents.
To persecute, not prosecute, but persecute his enemies.
Take a wrecking ball to the rule of law.
He's going to make the law. Everyone else will have to follow.
A vote for Donald Trump may mean the last election that you ever get to vote in.
To go after independent and free parts of American civic life.
He would tear down our institutions. Purge the government of employees.
Department by department effort to weaponize the powers of the government.
To use the military to quash protests.
Ridding the government of all democratic safeguards.
Junking American democracy as we have always known it.
That he would try to stay in office beyond a second term. That he would never leave office.
There's no question.
No doubt.
Trump is reelected, he won't leave.
Donald Trump will never leave office voluntarily.
And what that means is that everybody who wants us to remain a republic has to put every other thing aside and work together urgently right now to stop that from happening.
Amazing. Okay, so be sure, my friends, that you check out Grabian, okay? news.grabian.com. They're responsible for that mashup. I did not do it. It was incredible. If you want to follow the people behind it, a great follow is Tom S. Elliott there. Supercut saying that if Trump wins, America's over, man. It's all done. We're all done. And so certainly that is on my timeline if you want to go check that out and give Tom S. Elliott a follow because it was outstanding, right? They're basically talking about all the things they're doing to Trump. He's going to weaponize the Justice Department. You go, hello? He's going to imprison his political opponents. Hello? That's what you guys are doing. They know they're doing that. They just don't want it to happen to them, which is why they're so freaked out. And they are freaked out, man. All these indictments are not working and they're going, uh-oh, we cracked the seal. If we start indicting people, that means Trump, when he gets power, he can start indicting us. Uh-oh. And so not a good day for Jack Smith and Judge Chutkan. This is going to be a lot of fun. The Supreme Court is going to be hearing it, and we're going to talk about the appellate court next in our next segment. But my friends, thank you for subscribing wherever it is you're watching us. Thanks for checking out robertgovea.com, our website. We got a new shop there where we've got some amazing new gear. Learn about the Watcher symbol. Learn about the new gears that we've got. And thanks for getting something for the Christmas holiday season, supporting the show, and checking out the things that we're doing at robertgovea.com. We'll look forward to seeing you there and back here on the next one.